Happy Monday. It's Jackie Broman here from TBA Law, doing my standard Monday morning Facebook Live for you with the short snippets of information. So this week I wanted to talk about the duties and responsibilities of attorneys. So these attorneys are the people appointed under a power of attorney. So it's generally another family member. When people come in to do their estate planning, generally they choose their spouse as the first attorney, and then as alternative attorneys they choose usually one or a multiple amount of their children. So that's the typical scenario. So the people who are appointed under a power of attorney, what are their duties and obligations? So firstly, I suppose, is, well, when do your powers even begin? That depends on the document, the power of attorney document itself. So some powers of attorney begin immediately if that's what the person wanted. Some begin only if a specific event occurs, like being overseas, or sometimes it begins on someone losing capacity, which are the majority of the powers of attorney. In which case, the power doesn't begin until the attorney has a medical certificate saying that the person has lost capacity. Now, sometimes people can lose capacity in relation to some things and not others. So the power of attorney, the medical certificate needs to be quite specific, whether the person has lost capacity to make decisions about their finances, but can make other decisions about their own lifestyle still, and things like that. So if a power of attorney begins immediately, the attorney can't just go running around overriding the person's own decisions. The person's own decisions are paramount. The attorney is really just there to act under direction or do bits and pieces that the attorney, it's too difficult for the attorney to do. So that's when it begins. So then who is in the role and how do they make decisions? So I was sort of talking before about whether the person has capacity or not. If the attorney begins immediately, then it's not relevant whether the person has capacity or not. Once they've lost capacity, obviously the attorney has complete power because they won't be overriding someone else's decisions. But certainly whilst the person who's appointed you still has capacity, can't go running around overriding their decisions. Now, people can also be appointed, I generally say up to 4 people can be appointed as attorneys at once. Now, you can have attorneys act jointly, in which case they have to act together, countersign and make decisions together. Everything has to be done together. This obviously adds a level of protection for the person because someone's not running around by themselves doing things. However, on the practical side of things, with distance where people live, etc., it might be more practical to have someone be able to act alone. So if 2 or more people are appointed as attorneys, you can have them act either severally, which means always separate, or joint and several, which means they can act together if they need to, or separately if they need to. So again, the body of the document is fairly important to look at for both when the power begins and how the attorney can use their power. The other thing to check on the document as well is what sort of matters the attorney can make decisions about. So quite often it'll be a blanket power of attorney, which means they're giving all their powers that they can give. Now, if the power of attorney document was before 2015, it wouldn't have included personal powers and will only have included financial and legal powers. After 2015, you can have a combination. So someone might be given all powers, or someone might be given powers in financial circumstances up to decisions of $20,000 but no more, or someone else might be given decision-making powers about personal things and not financial things. So again, the document's pretty important to have a look at. Now, the type of financial and legal decisions that you can make if you have the broad power include all financial or property affairs, including any legal matter relating to financial or property affairs of the person appointing, including dealing with rates, taxes, insurance, doing transactions in relation to real estate, and paying bills and investing funds. Now, the things that an attorney can't do include, you can't vote for the person. You can't revoke or make a new will. You can't revoke or make a new power of attorney. You can't consent to marriage or dissolve a marriage, as in divorce. You can't make decisions about the adoption of a child. You can't make decisions about the person's estate after they've passed away. So that's a pretty key concept there. So the power of attorney document itself finishes as soon as the person themselves passes away. Okay, and then the person with powers after someone passes away are the executor in the will. So different roles under different documents. Now, a little bit more formal in the legislation, what the duties of the attorney actually are. To act honestly, diligently, and in good faith. To exercise reasonable skill and care in doing what they're doing. Not to use their position or their appointment to profit. Avoid acting where there's a conflict of interest. And to keep accurate records and accounts. So an attorney can never mix their own funds with the funds of the person that has appointed them. So they can operate the person's account, keep everything separate. I tell them start keeping a little book of everything they do. If they deal in cash, cash can be a problem. You need to keep all the receipts. If you're taking cash out, what are you spending the cash on? Otherwise, use the card, because at least then every transaction is recorded on the bank statement. You can't be paid for your role unless the person specifies that in the document, and that's very rare that they do that. It is a conflict of interest, and I quite often have this situation where mum or dad is declining and they want to transfer their property while they're still alive to their son or daughter. However, the son or daughter is appointed as a power of attorney. So there's a huge potential for a conflict of interest there. If the person can still sign for themselves, and if we can have different parties acting for each person, and there's a doctor's certificate to say that person still has capacity, then yes, it's still possible to do such a transaction, but certainly not if the power of attorney is signing for themselves and for the person doing the transfer. It's a conflict of interest to transfer any property to yourself, or to take funds from the person you're appointed for. You can't take funds for yourself. You can't give gifts to yourself or your children on behalf of the person you're acting for. Now, you can provide for the dependents of the person you're appointed for if they have minors or someone else living with them who are dependent on them, or perhaps their spouse who is declining. When acting in the best interests of the person you're acting for, it's more than likely going to be also what they would want to look after the person who's dependent on them. So in the powers of attorney we prepare, we put in the specific power that the attorney can take care of dependents if needed. It's not a given though, and so if you've got a more general power of attorney that doesn't actually say that, it can be a little of a grey area. So you just want to be careful, particularly where there's conflict or disputes in the family about doing anything like that. So This topic was a little dense. I suppose the moral of the whole topic today is to read the document, check what powers have been given and how you're able to utilise those powers when it begins. And then also keep in mind your obligations, which are to act in good faith and in the best interests of the person, to keep proper books of account, not to mix any funds with your own, and to avoid any conflict situations. So that's the summary. If you know of anyone who has been appointed as an attorney and would benefit from this video, it'll stay in the Facebook feed, so you're quite welcome to tag them so that they can look at it at any stage in the future. Otherwise, I'm going to leave you to the rest of your Monday. I'll be back again Facebook Live at 10 a.m. next Monday. If you have any questions, you're quite welcome to contact us through direct message on Facebook or on our website. You can find all our emails. It's fairly easy to find us and email us directly with a simple question. We're quite happy to answer that for you. If it's a little more complex, that's when we really need you